I am going to introduce an associate member and a good friend to TAG, Mike Gershon, who's a principal with Lloyd Gosling Attorneys at Law, and he will provide the introduction for our exciting morning keynote. So let's give Mike a round of applause and welcome this morning.
18 years ago, the Texas Supreme Court decided a simple rule of capture case, very similar to the East case. Just as in East, an industrial water user had drilled brand new, high-capacity wells that severely depleted its neighbors' wells. There was no groundwater district in the area. The neighbors had no leg to stand on under the rule of capture. At the time, the rule of capture had been abandoned by all states but Texas, so the plaintiffs took a shot to ask the court to replace the rule. The court ruled in Ozarka's favor, and its decision to uphold the rule of capture was not remarkable in that respect, that Ozarka won the case. But the reasoning of the decision was very telling. The concurring decision by our Chief Justice Nathan Hecht was profound, and that's why he is with us here today. It was only appropriate then in Chief Justice Hecht's 1999 decision, as it is this year on the 100th anniversary of the Conservation Amendment, to note that the people of Texas gave the legislature not only the power, but the duty to pass laws for the conservation, development, and preservation of the state's natural resources, including groundwater. At the time of the decision in Cipriano, Senate Bill 1 had been passed, and there was talk of Senate Bill 2. At the time, there were only 42 groundwater conservation districts in the state, but plenty of work on the ground and at the Capitol discussing the formation of dozens more districts. It's 18 years later. Water is still a top priority for our growing state. Both the legislature and the Texas Supreme Court have been at work. We're all familiar with the Day McDaniel decision, Guitar Holding. Day provided clarity on groundwater ownership. Coyote Lake Ranch v. Lubbock was recently decided, indicated the court's willingness to apply principles of other areas of law, including oil and gas, in the groundwater context. This audience certainly remains interested in what other precedents, whether it be oil and gas or otherwise, might apply beyond ownership in place, adopted by the court, beyond the accommodation doctrine, and whether the legislature or courts will affirm or rework current options to groundwater permit application. And we look forward to Chief Justice Hecht's insights today. Thank you, Chief Justice Hecht, for your guidance and wisdom, your service to our country as a naval officer and on many leadership roles over the years, as well as an elected Texas judge. For over 35 years on the bench, in state court as a district judge, as a justice at the Court of Appeals, and as our state's longest serving member of the Texas Supreme Court. Please welcome your Chief Justice.
Thank you, Michael, and thank you very much for the invitation to be among you today. I must say, if you had invited me on Friday, I would have declined because our court has been very busy the last several days issuing emergency orders to keep the courts in the Gulf, in the coastal area, functioning. It's a big struggle for many of them. The Rockport courthouse is unusable where the storm came ashore, and all up and down the coast, judges are struggling to get to facilities and be able to conduct proceedings that are very necessary, even though the flooding is and the rescue efforts are number one priority. So, but I am glad to be here. I think the courts have survived well in the coastal areas, and the judges there have done a lot to ensure that they'll be in business throughout these few days of difficulty. And I commend all of them, and our hearts and I know our prayers go out to them and the other victims of the storm. And it's ironic, as Michael said, that we meet here on the 100th the 100th anniversary of the Conservation Amendment, prompted by a flood, and here we sit between droughts and floods with some of the same problems that we faced 100 years ago and before. My father, just for point of reference, was a dryland farmer in Curry County, New Mexico, and when I was a little boy, dry was the operative word in dry land. It was very dry out there. My grandfather we think he drilled the first well in Curry County, New Mexico, into the Ogallala and pumped water from 425 feet below the surface, which nobody thought was even possible at the time. And the desert bloomed, and the farming conditions in that area changed dramatically. We were usually worried about the drought, but one week I remember growing up, it rained for more than 7 days, and my father said the only thing worse than 7 years drought was 7 days of rain. I think the people of Houston would agree with that right this second. One thing about that experience growing up was I learned that water conditions change. When my grandfather drilled that well, there was all the water the area could use in the reservoir. We did not anticipate at that time, the handful of farmers in that region, that there would ever be a shortage of water. It was like water forever. Then, after thousands and thousands of wells were drilled into the Ogallala and the water table began to decline, people became concerned that it might actually run dry. There might actually not be water there at all. Then when natural gas prices went up and it became more expensive to get it out of the ground, so the water table went up as well. And so it has shifted back and forth over the years, and that's the nature of the problems that we face in trying to assure that groundwater is being put to appropriate uses. Let me just say at the outset, I don't think we have any water cases pending right this minute, but if we do, and I haven't seen them, I'm not, please don't take from my remarks today that I'm commenting on any case that is before us or could come before us. I'm just telling you what I think you could observe yourselves from the decisions that we've issued over the years. The interesting thing to me as a judge about groundwater law is that it comes originally from the common law. And the common law, you may know, the lawyers all know this, but some of you others may know that the common law is a way of developing law through court decisions. So disputes are brought to courts, they resolve the dispute, they write down what their decision was and why, and then in the next case they try to do consistently, make a consistent decision. And so as more and more cases come on a particular issue, the law takes a direction. It's not sitting down and saying, okay, now what should the law be about this or that subject, like the legislature does, Senator Perry. It's more taking each case as it comes and seeing how that makes the law develop one way or another. And in Texas, it's a little more complicated because even though the state adopted the common law of England in 1840, we followed the civil law of Spain and Mexico before that. And so there's an enormous influence of the civil law, Hispanic civil law, on the state, as well as the English common law. And then, of course, the Constitution trumps everything, and the people, for example, in the amendment, in the Conservation Amendment, have expressed a view about how water and other resources should be regulated, and statutes can affect the common law and modify it, reject it, put something else in its place. Just to give you another illustration of the common law, tort law in Texas and in almost all states started out almost entirely common law. just in the course of court decisions, the law of assault or battery or negligence or other torts took shape. Now, in more recent times, legislatures across the country and the Congress have come in behind the common law and said, no, we want there to be these differences. We want there to be these maybe procedural differences or substantive differences, new causes of action, limits on other causes of action. That's a different source of law. And the same thing has happened to the common law, which is where water law has come from. Originally, it was almost entirely common law, and now with groundwater regulation, there have been changes in what would otherwise be the common law. But the common law has not been rejected. It couldn't be. It fills too many spaces, and so it remains there in the background, along with the statutes passed by the legislature and the Constitution adopted by the people. So how does a court like mine decide what the common law should be? Usually, when a court is deciding a case and it involves a statute or a contract or something in writing, we look at the words and we say, what do the words mean? What did the parties intend? What did the legislature intend? What does this say? And then we say, whether that's a good idea or a bad idea, that's not our call. We do what the parties have agreed to, what the legislature has enacted. That becomes the source of our law. But there is no such thing with the common law. And so courts do what other lawmakers do. They look to history and experience, policy. We look to the law of other states. We look to pragmatics. We resort to first principles. We look and see, well, if you were writing on a clean slate, what should the law be in these circumstances? What would best address these problems? Much the same way the legislature goes about writing statutes. The genius of the common law is that it tries to take all of that into account. It looks at real life experiences, it looks at the realities, it looks at changes that have happened over the years, and it tries to adjust what the law should be in response to those factors. The limits on the common law are that it's made by judges rather than elected political representatives, and so judges are distanced from the people more than our elected representatives are, and so it does not have that closeness to constituents that statutes have. And it's not, common law is mostly not politically influenced, and maybe that's good, maybe that's bad. In some respects, when political times are changing, maybe it's good to have the stability of the common law, or maybe not, maybe it should change as well, or maybe it's bad to distance political realities from the common law. But that's the kinds of things that courts take into account. So let me show you how that is, and then try to make some observations of where I think what we've said so far is going, although, as I say, I don't mean to comment on any case that might come up. In 1904 in East, we had the classic problem. The railroad is pumping 25,000 gallons a day. Mr. East, sitting very close by, has a little bitty 35-foot deep well. He's just trying to get enough water out for his household use, and he says his little well dried up because the railroad was pumping all the water. And the case came to us. And so we cast around for a rule, and because the people had adopted the English common law, we looked to the English common law. And under that law, the rights governing surface water and groundwater were different. And generally, for surface water, the rule was reasonable use. The people near the surface water had to make reasonable use of the water. That didn't solve every problem, but that was the general rule. For groundwater, an 1843 case had decided in England that you could use all you wanted. That we called that the rule of capture. We didn't call it that in East. but we called it later the rule of capture, which meant that you could take what you could get out of the ground, and if that impinged on the access to water of neighbors, their recourse was not to sue, but was to drill their own well and pump themselves. About the same time, we adopted that rule for oil and gas use, and so we have said that, generally speaking, initially, that oil and gas well owners could pump out as much as they could pump, and if someone else complained, a neighbor complained that it was draining, it was actually taking oil from underneath their property, their remedy was to drill another well. And there would be exceptions to that. You couldn't do it maliciously to hurt somebody. You couldn't do it willfully. You couldn't just do it wastefully so that the resource could not be recovered. But short of those kinds of exceptions, that would be the rule. And we said it was the rule for three reasons. We said, first of all, you can't tell where the water is, so how do you know for sure that the railroad is pumping the little homeowner next door, pumping his well dry? How do you know that for sure? Well, it's pretty easy in that situation to tell, but there would be cases where it would be harder, and we said, we're just not going to get into that. We said it would interfere with progress because obviously the court took a pro-use view then. The more water you pumped out, the better off the state would be. It would, besides interfering with progress and hard to tell which way where the water was moving, this was the rule in most states. Every state except New Hampshire, we thought at the time. And any state that has a motto, live free or die, we said, well, who cares what they think? So we did it because for those three reasons. Now all those reasons are gone. We can tell, not with certainty, but to a greater degree, where the water is and how it's moving. It may, restricting use or having lawsuits over the use of water, that might interfere with progress. It might promote progress. It could go either way. And no state follows the rule of capture any longer except Texas. So what the common law can give, it can take away. And in 1955, in a dissent, Justice Will Wilson said, we may not always have the rule of capture. It was a court-created rule in 1904, and the court can take back what it gave in East. In 1999, Michael referred to the Cipriano case. We had virtually the same situation that we had in East. The court decided to follow the rule of capture, to stick with East going forward. But Justice O'Neill and I said, well, okay, there are good reasons to do that, and there are good reasons to stop. And so right this minute, we think the reasons to continue forward outweigh the others. Principally two reasons. One is that tort lawsuits are a very bad way to regulate conduct. I know there are theories to the contrary. I know my good friends in the plaintiff's bar would say the lawsuits do have a positive influence on things, and sometimes they do, that's true. But generally speaking, it's a pretty heavy-handed way of trying, a remote way of trying to move the law forward. The second reason why Justice O'Neill and I thought that we should stick with the rule of capture for the time being is that the legislative regulatory efforts were premised on that. All of them took as a given there would be the rule of capture if they didn't do something to modify it. And to suddenly remove that as the basis for the regulatory efforts it would be difficult to predict what effect that might have. It could be very disruptive on legislative efforts, and as Michael said, right then Senate Bill 1 was being debated, and so it would have an effect on that. And so we said, okay, just as Justice Wilson had said in 1955, we'll keep the rule of capture, but we could change our minds going forward at some point. Interestingly, after the Cipriano case came out, Chief Justice Phillips and I were friends with Governor Bullock, and I don't know why. We were young Republican judges, and he was an old Democratic, longtime Texas politician, but he liked us for some reason. So he called us and he said, get over here. I want to talk to you. So we trundled over to the Capitol, and he said, I just want to tell you boys, I thought that Cipriano case was a great decision. He said, you're exactly right, leaving this in the hands of the legislature to solve. We got Senate Bill 1 here. We're going to do a lot of good, and I just want to commend you for doing the right thing. Governor, thank you very much. We went back to the courthouse, congratulating ourselves. The next morning, I picked up the Austin American-Statesman, and there was an editorial by Bob Bullock says, well, the Supreme Court really let us down on this one. They had a chance to exert some real leadership here, but they dropped the ball. That's what courts and judges do. They don't know what they're doing. But thank God there's a Texas Senate, and we're going to do the right thing. So I went over and I walked over again. I said, Governor, I thought you said we did do the right thing. And he said, oh, I was just funning with you boys. He said, that's the problem with you judges. You can't take a kidding. He was an interesting fellow. Will the Supreme Court abandon the rule of capture for correlative rights, reasonable use, some other sort of rule in cases going forward? As I said at the beginning, I don't know, and if I knew, I couldn't comment. I really don't, but let me note the obvious things that you can see for yourselves. First of all, water law has been heavily influenced in Texas by oil and gas law. So when the court was looking for principles to justify a rule going forward, when we were looking for things that would work, that had been tried in other areas of the law and had been shown to be effective, we looked to oil and gas law. And so in the Day case, we said, we held that the surface owners own the groundwater in place. We'd said that about oil and gas, 60 or 70 years ago. States differ on that. Some states say you do, some states say you don't. But the rule had worked pretty well in Texas without incident, and so it seemed important to sort of keep consistency there, and we went to the oil and gas rule. We also pointed out in the Day opinion that that the rule of capture would serve to inject another consideration into regulation of groundwater use. So the rule of capture does not prevent regulation. It is just a factor that has to be considered, we said, in groundwater regulation. So the problem in Day, the smaller factual problem, was that the landowner had not used very much water for a while because he had decided that he didn't have a beneficial use for it, while neighbors had used more for a longer period of time. Then when regulation came, that was when water was unregulated. When regulation came along and said, well, we're going to look principally at historic use, then that meant that because they had been, in essence, conservative in their use of water for the years, they would be entitled to less going forward. And we said, no, that's certainly a factor to be considered, but it can't be the only factor. You can't take away the landowner's access to groundwater beneath his property just because he hasn't used it for a period of time. You can consider that factor, but that can't be the only consideration. And we drew that rule from the oil and gas law. That, as you probably know, that's the way oil and gas works. On the one hand, the landowner owns the minerals in place below the surface, but on the other hand, there's extensive regulation of the pumping of production of oil and gas. There's space rules, and they differ in different areas. Production can be limited, wells can be shut in for periods of time. There are all sorts of regulations governing the production of oil and gas, even though the landowner owns the minerals in place, and they operate consistently. In fact, we said in Day that correlative rights in oil and gas are a function of the regulatory process. They're not a standalone common law creation. They're just because of the way the regulatory system functions, there are correlative rights. In Coyote Lake Ranch case, just 2 years ago, a year or two ago, we looked at oil and gas law for the accommodation doctrine. And said that the surface owner must accommodate the groundwater owner in producing groundwater. We've had the accommodation doctrine in oil and gas for about 40 years. It was a court creation, it was common law. It's worked very well. We have very few cases on the accommodation doctrine in the last 40 years. And the reason is because most of the time landowners and mineral owners work out a reasonable approach to the production of the minerals. In a case that it does not apply to water yet, but we have had the issue come up a couple of times in cases. In Coastal Oil, in an oil and gas case, we said that the rule of capture precludes suit for trespass against your neighbor. So the claim in the coastal case was that fracking of a well had extended past the boundary lines going down into the ground of the fracker's property and extended over into the neighbor's property, and thus was allowing greater production of minerals from the neighbor's property than would otherwise be possible if there hadn't been fracking. And we said, no, the rule of capture governs that. In those circumstances, you can't sue for trespass. Again, the recourse is some sort of regulation or drill your own well. You can still, of course, sue for drainage and waste, and there are all sorts of exceptions, but generally, we said that. We've had a couple of cases come up where there had been allegations of trespass into groundwater, but the issue has never been quite teed up, and so we have not had to decide it. But that is another area where oil and gas has tried to solve a problem before it has come to groundwater rights. But oil and gas is not a perfect fit. The economic interests in producing minerals and producing water are different. And most of the interests in producing minerals, at least heretofore, have been economic, whereas much of the interest in producing groundwater is economic in the sense that it's agricultural, but non-economic in the sense that it is just used for consumption for survival. And so they're not perfect fits. Oil and gas is a lot deeper. The risks of contamination are different. They're just different social concerns in regulating water and regulating oil and gas. So my point is that while we have looked to oil and gas law to help us develop common law rules for groundwater that may not always be possible. The analogies may break down at some point. The bottom line is that the court has said, I'm not telling you anything new, but the court has said that there is a reluctance of the judiciary to move to common law regulation by lawsuit, to some sort of reasonable use, where there would be litigation about what's reasonable, or correlative rights, sometimes first in time, first in right, or some other sort of litigation process. Again, just because of the court's view heretofore that was not the best way to achieve a use that's beneficial to the entire state. There's also been a reluctance, I said so myself, in Cipriano to disturb the legislative process. It's one thing that builds a lot of uncertainty into things is if one branch of government is changing the rules while the other branch of government is trying to work on what they thought the rules were. And so there has been a reluctance for us to disturb that process. But again, as we said in Cipriano, as Justice Wilson said in 1955, in the City of Corpus Christi case, it's only a reluctance. It's not, we are not committed to never looking at it again, and in fact, we're going to continue to look at it as the cases come up. How has regulation come along after Day? I'm only looking at this from a distance. We had the guitar holding case, where we said, again, you can look at historic or existing use, but it's only a factor. It's not the only factor. The allocation issues that we face today are clearly political. People of Texas feel very strongly about what are better and not so good uses of water. Coming from being raised by a farmer, I thought that agriculture was pretty important. But again, times change and we have to keep looking to see. I know the city of Lubbock and the city of San Antonio, just to pick two, struggle with drinking water access. Those are certainly issues that we have to contend with, as is commercial use. We also have moved to an expansion of groundwater districts, as you all know much better than I do, although they still do not come anywhere near covering the state, and so much of the groundwater use is not regulated at all. And one thing that we've not thought much about, we've not had any cases on this, but there is a case out there in groundwater district operation, is that the legislature, in Texas at least, must provide some guidance to agencies to how to regulate. Texas is different from the federal government. So in the federal government, it's long been true for decades. It wasn't always true, but it's been true certainly in the last 40 or 50 years, that the Congress just delegates very broad authority to a federal agency, go and make rules and do whatever's right. So they have a lot of authority based upon very general organic statutes. The law in Texas after the Texas Boll Weevil Eradication Foundation versus Llewellyn decision in 1997 says, no, in Texas the legislature has to provide more guidance than that to unelected officials who are just exercising the authority of agencies. And so that would apply to groundwater districts, elected or unelected. We've not had challenges to groundwater district regulation since guitar holding that raised this issue. The district has run amok. It's using authority that the legislature never gave it. We haven't had that issue, but the boll weevil case is just a reminder that the responsibility, ultimate responsibility at this point in our state's history lies with the legislative branch. We assign opinions randomly at the Supreme Court. We draw for them. Different courts do it different ways. And it was just the luck of the draw that the Day case came to me and the Coyote Ranch. And of course, I wrote separately in Cipriano. But whether you write the case or whether you're just voting on it, the judges are deeply engaged in the issues, and I know that all the members of the court think that the issues in these cases are deeply interesting. Michael said, well, one thing that really disturbs the system is uncertainty, and we need as much certainty and predictability as we can. And of course, we are very sympathetic to that, but some of these issues just have to evolve and don't have a clear answer yet, so we'll have to wait and see how things develop. But I'm confident that the regulatory process that the legislature has set up so far has been entrusted to experts like yourselves and people who are on the ground and who are seeing the realities of groundwater use and are sensitive to the priorities and claims on this precious resource that we have, protected even by our own Constitution. And I am confident that with that work in your hands, it has been well placed. I'm very grateful for you to have extended this invitation to be among you this morning. Good luck in all your work, and God bless you.
Chief Justice Hecht, profound and insightful words again to your state's water leaders in this audience. As one token of our appreciation, we've got a natural history guide on water in Texas, authored by Dr. Andy Sansom, who offices down the street, lives in Austin. And he's written a personal note to you that I'll leave it to you to read in confidence. But thank you for your time today and your remarks. I know that Sarah Schlesinger has some words for you as well. Thank you.
Thank you.